Hi, everyone. Welcome. We are going to wait a few minutes before starting just to allow everyone to come into our room, at which point I'll introduce the event and our speakers. Okay, so we're about 2 minutes past the start time. So why don't we get started with our event? We do have a full time packed with various speakers. I'm Amy Salazin. I'm a professor here at the University of Ottawa's Faculty of Law. I'm very delighted to be here with you today to launch the Conway Professionalism Speaker Series and to hear from the Treasurer of the Law Society of Ontario, Teresa Donnelly. As an initial matter, I did want to acknowledge that the University of Ottawa is located on unceded Algonquin territory and to pay respects to the Algonquin people who are the traditional guardians of this land and acknowledge their longstanding relationship with this territory. And also to pay respects to all Indigenous people in this region from all nations across Canada who call Ottawa home. As I noted at the beginning of my remarks, today is the launch of the Conway Professionalism Speaker Series. It'll be the first of many events in which we will be hosting at the law faculty various speakers to discuss matters of professional responsibility, legal ethics, the regulation of the legal profession. And I wanted to give my thanks to the Conway law firm for their generous financial support that will allow us to do this. It's very exciting for us to be able to partner with such leaders of the Ottawa Bar and to be able to have such events where we can bring together in Ottawa law students, lawyers, academics to talk about the important issues that the legal profession is facing. And of course, I'm extremely delighted as well that we're able to launch this event with such a wonderful, engaging leader in the legal profession, the Law Society Treasurer, Teresa Donnelly. And I know the interim dean, Ellen Russi, will be introducing Teresa later. Right now, I wanted to introduce you to Tom Conway, who is here with us, a founder and partner of the Conway firm. Tom's accomplishment and leadership in the legal profession are many and profound. Many of you in this room probably already know him from your work in the bar or work at the law school as well. We do have a packed agenda today, so I don't unfortunately have time to go through kind of a full list of these many accomplishments. I do want to give Tom a chance to speak as well. One thing I did want to highlight that I thought was relevant for today was, of course, Tom was the treasurer of the Law Society back when it was the Law Society of Upper Canada, I think, between 2012 and 2014. And in that capacity, actually came to our law school to give a treasurer's talk. So a bit of a first full circle today, which is wonderful. And with that, I think, Tom, I'll turn it over to you to give some opening remarks as well.
Thank you very much, Amy. In a scholarly article published in the Alberta Law Review in 2018 entitled Risk Regulation for the Legal Profession, authors Professor Adam Dodek and Emily Alderson wrote, and I quote, "The winds of change are blowing over the Canadian legal profession. The increasing pace of change caused the Law Society of Ontario's former treasurer, Thomas Conway, to remark in 2013 that more changes had occurred in the regulation of the legal profession over the last 20 years than in the previous 200. Conway was not exaggerating," unquote. I gave those remarks at this same professionalism lecture series on April the 3rd, 2013. So fast forward to early March of 2020, I was traveling from a court appearance at Osgoode Hall in Toronto with one of my colleagues. And as we walked through the tunnel at Billy Bishop Airport, we passed Dean Adam Dodek, who was then on his way to Toronto on faculty business. And as we passed each other, he and I committed to getting together soon to continue our discussion about a proposal to have our firm sponsor this lecture series. The Friday of that week, March 13th, 2020, I argued one of the last civil motions to be heard in the Ottawa courthouse before the COVID-19 lockdown. And later today, I understand that the Chief Justice of the Superior Court will be announcing plans to reopen the courts in early April. So spring is in the air. Let us look forward and hope for better days. But looking back on my remarks in 2013, however, they reflect another time. In hindsight, perhaps a naive time. The concerns we had then as legal professionals pale by comparison to the challenges the world faces today. In 2022, I would say that the world has changed more in the last 2 years than it has in the previous 70. And I don't say that with hope or optimism. World events impact the legal profession, since lawyers, judges, academics, regulators, and other legal professionals are involved in every aspect of life where the rule of law prevails. That is why, in a world that is now marked by unimaginable suffering, conflict, division, and hatred, it is more important than ever that lawyers define and understand the ethics, the mores, and the values that are common to our profession, whether as academics, practitioners, or lawyers working in other fields. Because without defining and knowing those values, we amount to no more than a collection of mercenary technocrats. We will not be able to make any real or lasting contribution to addressing the solutions to problems that loom ahead for your generation of lawyers. Any good, competent lawyer must have at least a working knowledge of their professional responsibilities. But in my experience, the most accomplished and respected lawyers, judges, and academics are invariably individuals who not only have a working knowledge of their professional responsibilities, but who embrace them, who put professional ethics and professional responsibility at the forefront of their minds in their daily activities, such that they have become habits of thought that never fail them. So on behalf of my firm, I want to express our thanks to the faculty for the opportunity to sponsor this professionalism speaker series. I also want to thank my law partner, Marion Sandilands, who took on this project from our end with such great enthusiasm. She and the other members of our firm are delighted to be associated with the Faculty of Law in this endeavor. In a time when the words we hear and read of world events seem so negative, we are pleased to support an ongoing dialogue about professionalism and the common aspirations and values we share as legal professionals. At a time when the world seems to be all negative, it's good for us to think about those common values to which we all aspire. No matter our background, no matter how difficult our individual journeys have been to get here into this law school, we are all privileged to have been afforded the opportunity to learn the law and to serve others with our specialized knowledge and experience. And for that, we should all be thankful. And I certainly am. My career has been rich and rewarding. So on a personal note, sponsoring this series permits me in a small way to thank my law school for, first of all, being kind enough to let me into the faculty, and even kinder in permitting me to leave the faculty with a law degree. I wish you all every success in the start of your legal careers. And finally, I cannot help but note that on this St. Patrick's Day, when all of us are Irish, at least for a day, we are kicking off the Conway Professional Series with a talk from the current treasurer, Teresa Donnelly. Teresa Donnelly, our ancestors would be very proud. Thank you for the opportunity to make those remarks.
Thank you so much, Tom. I was going to start with something else, but I guess I should start with Happy St. Patrick's Day. But anyways, thanks for those remarks. For those who don't know me, my name is Alain Roussy. I'm the interim dean of the Faculty of Law, Common Law section here, at least for another approximately 28 days or so. We do have a brand new dean coming in mid-April. So it's my pleasure to welcome you here. It's my pleasure to welcome Tom and Teresa in particular joining us today. And before I introduce Teresa, I do want to echo Amy's thanks to Tom and his firm for their contribution to this, to our faculty, and for making sure that this professionalism speaker series remains alive and well, hopefully for many, many years to come. So it's my pleasure to introduce our main speaker. So Teresa Donnelly was elected as treasurer by the Law Society's governing body in June 2020 and acclaimed for a second term in June 2021. As treasurer, her work has focused on a number of priority items, including, to name just a few, the importance of the well-being of legal professionals, equality, diversity, and inclusion, the important role that paralegals play in access to justice in Ontario, building awareness among lawyers, paralegals, and law students about the role of the Law Society, which is perhaps partly why she's here with us today. Treasurer Donnelly was elected as a bencher in 2015 and again 2019. Before that, as a prosecutor with the Ministry of the Attorney General for 26 years, she has dedicated her career to providing access to justice for victims of domestic and sexual violence, the majority of whom are women and children. As the West Region Sexual Violence Crown with the Sexual Violence Advisory Group with the ministry from 2015 to 2020, she was one of 7 prosecutors in the province dedicated to enhancing the quality of sexual violence prosecutions and the victim's experience in the criminal justice system. She was called to the Bar of Ontario in 1991 and received her LLB from another university in 1989. So again, Teresa, thank you so much for being with us today. Last little item of business before I turn it over to you in terms of Q&A. So this is, as you know, for those the 64-ish people who are with us right now. Well, again, thank you for being with us. In terms of questions, please don't be shy to ask your questions, and please do so in the chat. So the questions will be addressed by the treasurer at the end of her presentation. So again, please don't be shy and please do so in the chat. Thanks very much. And I turn it over to you, Teresa.
Thank you so much. So Tom said about how things have changed so quickly. And my talk to you is going to be take into account that change, because I'm going to ask you to pick up your cell phone. This isn't going to be a talk like where I'm standing in front of you as it would have been pre-COVID. This is going to be an interactive chat. So I'm asking you to pick up your cell phones and if you could use this, so you can, I want you to go to either use the QR code here, or another way you can do it is you can go to Menti. So it's menti.com and use the code at the top of the screen. So the code is 98995945, and that code will be on every slide in case you don't get on or something happens. So it's menti.com 98995945. So for our first chat with everything that's happening, I thought we should talk about being called to the bar. And to get us ready, I'm going to ask you to tell me what the Law Society of Ontario does. So if you're on Menti, menti.com, what I want you to do is I want you to type in a word about what the Law Society of Ontario does. Great. Okay. So, and you can keep, so just for those who haven't figured this out yet, if you want to participate, go to menti.com and use the code 98995945. Okay, we're going to keep going. So very good. Excellent, in fact. You can see it's changing, regulation being the number one, and that's right. That's what we do. You hear things like in this word cloud, discipline, competence, good character, regulation of the profession, audits, enforcement. So very good. So here's, if I could just go to the next slide. So what we do then, I'm having a little bit of a difficulty. Here's who we are and what we do. We're self-governing, which means we as lawyers and paralegals and lay appointees appointed by the Ministry of the Attorney General have the privilege of regulating ourselves, regulating the lawyers and paralegals. And we do so to hold that privilege, we do so in the public interest. And we do it by ensuring that the people of Ontario are served by Ontario lawyers and paralegals who meet high standards of learning, competence, and professional conduct. And we also facilitate access to justice for the public. So let's go to our next question. How many lawyers are currently licensed in Ontario? 42,000, 57,000, 64. Okay, so pretty close between 64,000 and 57,000. And the answer is we have over 57,000 lawyers and over 10,000 paralegals. You'll also see when you look at the bottom 4 bullets there that we licensed 2,500 lawyers last year and 1,200 paralegals. Let's go to our next question. So our question is, to be licensed by the LSO, candidates must be competent and conduct themselves with integrity, honesty, and must be of good moral character. True, false, or uncertain? Okay, good. And just for others who are listening and want to join the Menti code, go to menti.com and the code number's at the top. True. So this is set out in the Law Society Act, section 27(2), the requirement that for the issuance of every license, that the applicant be of good character. Good character is not defined in the Law Society Act. It's defined in the jurisprudence of the Law Society Tribunal, connoting moral or ethical strength, and being a combination of virtues or traits, which include integrity, candor, empathy, and honesty. And the leading case on that being the Law Society of Upper Canada, Armstrong versus the Law Society of Upper Canada. Here's our next question. If you pass the Law Society's barrister and solicitor examination, are you automatically entitled to be called to the bar? True or false? Okay, so the 31 who said false are correct, because there's more than just passing the licensing examination. We know that because we've already talked a little bit about the good character requirement. So this slide tells you prerequisites for admission to practice law in Ontario, talks about the academic requirements, the registration, and that is that you would apply and pay applicable fees. You have to be of good character. You pass the examinations. You have experiential training, and also then you would be licensed. And the bylaws, Law Society bylaw number 4, subsection 8(1), sets out some of those registration requirements that were referred to on the previous slide. And again, application, pay fees, be of good character, take the oath or affirmation, and provide all requested documentation. So simply passing the licensing examinations is not all that you need to do in order to be licensed by the Law Society of Ontario. How about this? In deciding whether you are of good moral character, the Law Society does not look at your conduct at university or law school. Is that true or false? Well, overwhelmingly, those who said false are correct. So here's a question from the licensing application. This is question number 10, and it quite clearly asks questions about conduct while attending a post-secondary institution, about allegations of misconduct being made against you, being suspended, expelled, or penalized. And if yes, you must provide the details of the allegation, the suspension, the expulsion, and the penalty imposed on you. And this is an excerpt from a case before the Law Society Tribunal from 2021. And this was an issue of good character, and Mr. Polanski's good character was in issue. And this is a quotation talking about that the tribunal considered the conduct of Mr. Polanski while at law school, and that the dean of the school had sent a letter to Mr. Polanski about unacceptable and disruptive behavior as a law student, and that he wasn't allowed to return to class until such conduct ceased. So we see it in the licensing application. We see it again here in this decision. What about this question? Is character fixed so that either you are of good character or bad character and there's no way to change it? Okay, so, and what we see here in the results is that the answer is no, and that's correct. Character is not fixed. And so this is an excerpt from a recent case. Again, this one's a 2021 case from the Law Society Tribunal, making it clear that the act and the case law, the jurisprudence, make it clear that a person who has shown bad judgment or made questionable ethical decisions in the past can establish that they are currently of good character. And that's what the tribunal's looking at, is whether the person before them is currently of good character. And so this talks about you can demonstrate that by acknowledging, understanding, accepting, and addressing their past conduct, and they have evolved. What about this? If you commit a criminal offense and serve a jail sentence, are you prohibited from being licensed as a lawyer in Ontario? Okay, so we look at that, and the no's have the most support for that, for 21 saying no, and that is the correct answer. You're not prohibited from being licensed as a lawyer in Ontario if you have a criminal, if you've committed a criminal record or a criminal offense. So, and why is that? There's now the way the good character requirement stands is that it's set out, as I said, in the jurisprudence, what it means to be of good character. And the test that is usually used is the Armstrong test, a case I referred to on an earlier slide. And the test for of good character involves a consideration and a weighing of each of these factors: the nature and the duration of prior misconduct, whether the applicant is remorseful, the extent and success of rehabilitative efforts, the applicant's conduct since the misconduct, and the passage of time. So it's not that the bylaw says that a person is of good not of good character if they've committed a criminal offense. Here's a case. Again, a 2021 case where the applicant committed criminal offenses in his 20s, writing bad checks, pleaded guilty and was sentenced 9 months and 2 years, 9 months jail, 2 years probation. later pleaded guilty to a driving offense, was processed under the wrong name, had lots of opportunities to tell people what his correct name was and didn't, was then caught driving under suspension and then charged criminally. So that obstruct is a criminal offense. So had 2 sets of criminal offenses. And the tribunal found he was of good character. So the tribunal then again, looking at currently whether or not he was of good character, determined that he was, and looked at the Armstrong factors, including passage of time since the last incident, looked at the conduct since, including what he had done in the interim, and that had been to pursue studies, helping others in school and community settings. And although the misconduct had occurred over a lengthy period of time, the tribunal found that there had been a sufficient passage of time for there to be confidence that he had changed and that he had diligently and methodically worked to confront his mistakes, accept responsibility, and to move forward positively. So again, this the idea of current good behavior and that current good conduct or good character, and that character is not fixed. What about this one? Does it make a difference if the criminal offenses are really serious? For example, terrorism, murder, child sexual offenses. And so this is tied to the last question. And the last question was, are you prohibited from being called to the bar if you have a conviction for a serious criminal offense? So there's a little more uncertainty in this answer. So the answer is, does it make a difference? The question relates to whether or not you're prohibited from being called to the bar. So you're not prohibited from being called to the bar in and of itself, that you're convicted of a serious criminal offense and get a lengthy jail sentence. However, what would apply would be the Armstrong factors would apply. And it may be when you look at the Armstrong factors, including the nature of the misconduct, that on that ground, there's a very significant hurdle to overcome. But let's look at a couple of cases where people had been convicted of terrorism offenses. And let's see what the Law Society Tribunal did for those offenses. So here's one from 2020, and I'm going to talk to you about 2 cases here, one from 2020 and one from 2021. So this first case involved a licensing applicant who pleaded guilty to a single count of conspiring to provide material to support a foreign terrorist organization, and had received a jail sentence of 2 years in jail and 3 years supervised release. In addition to that criminal offense, had also been sanctioned for what was called unintentional plagiarism on a law school exam. So this was a matter, as I said, before the Law Society Tribunal, and the evidence was provided from the applicant and character witnesses, and there were over 90 letters of reference filed in support. The Law Society Council, Discipline Council, took no position on the hearing, and the applicant was found to be of good character. So you can see just by the fact alone that there was a terrorism conviction or supporting a foreign terrorist organization, that was not an automatic bar to being licensed in Ontario. And what about this one? This is really hot off the presses. This is an endorsement from March 11th, 2022, where the tribunal has released an endorsement. It's going to be releasing fuller reasons to follow, but has now said, after a hearing last week, that finding that the licensee is currently of good character. So this is from conviction from 2006, where the applicant participated in the unsuccessful attempt of the Toronto 18 to set off 3 bombs at 3 prominent locations in Toronto: the Toronto Stock Exchange, CSIS headquarters on Front Street, and an undisclosed military base. So the applicant was convicted of terrorism offense and sentenced in 18 years in jail, with his sentence ending in 2020. When at the time of the offense, so back in 2006, and when he was participating in the criminal offense, he was 18 years old and a first-year university student. And so this is only a brief excerpt of the endorsement, but the endorsement lists the people who testified at the hearing in support of the applicant. And ultimately, the tribunal found, with fuller reasons to be issued at a later date, but the tribunal looked at the Armstrong factors, looked at the assessment of good character, and found that his insight, remorse, and acceptance of responsibility were clear from his testimony and his actions, that they looked at what he's overcome and what he's accomplished. They looked at the respect and the support that he had earned from the people that he had been involved with over the course of being involved in the criminal justice system. And they ultimately concluded that the applicant was of good character. And as I said, there will be fuller reasons coming out about that. Okay, so what about the standard of proof is balance of probabilities, but who has the burden of proof? Is it the law society who has to prove that the applicant is not of good character, or is it the applicant who has to prove that they are of good character? Okay, and so we're getting overwhelming support for it's the applicant that has to prove they are of good character, and that's correct. So that comes from a divisional court case in Shore, but it also makes sense when you think through the process, and that is that the requirements to be called to the bar, to be licensed, as we said, include a number of factors, one of them being good character, and it's the applicant satisfying the licensing requirements. So how about this one? Is there a place in the legal professions for people who have made mistakes and learned from them? So we're getting everyone a unanimous yes, that there is. And if anyone's just joined and wants to join in the question and answers, you just go to menti.com and put in the code at the top of the screen. So yes, there is. And that's what we've just been talking about for the past 15 minutes or so. And that is about the good character requirement for licensing under the Law Society Act. And this is a quote from George, a 2020 case from the Law Society Tribunal, talking about rehabilitation and as it relates to the good character requirement. So what I've talked about in earlier slides, that the capacity in human nature for someone to recognize their mistakes, to make amends, to correct the course of their lives, and to become productive and positive members of their community. And again, applying the Armstrong factors that are set out there and making an assessment of whether the good character, the person is currently of good character. And here in this case, referring to George and saying that George was an excellent example of rehabilitation. So let's get to the licensing application. I already asked you one of those questions, and that was one about your conduct at law school and at university. But what about this question? So in answering your licensing application, say you admit a few things. So, you know, it's not an outright lie, but you admit a few things. Is that okay? Well, it's good that nobody thinks that that's okay, because it's not okay. Let's talk a little bit about that. So I already referred you to Law Society Bylaw 4. Here's Section 8. This is Section 8.2. And what it says is, an applicant who makes any false or misleading representation or declaration on or in connection with an application for license by commission or omission is deemed thereafter not to meet and not to have met the requirements for the issuance of any license under the Act. So that they're deemed not to meet the requirements to be licensed. So very serious result of these any misrepresentations, and that's including misrepresentations by omission. And here's a case, a 2021 case, where they were looking at a misrepresentation on a licensing application and looking at Section 8.2, because what they're focused on is deliberately misleading the Law Society in your licensing application. They talk about how important candor is. And you'll remember when we went back to one of the early slides when I was talking about good character not being defined in the Law Society Act, but being defined in the jurisprudence. And they were looking at things like honesty, integrity, candor. So, and here we see it again. Candor in the application process is an important indicator of good character. Conversely, lack of candor or deliberate suppression of information is an obvious indicator of a lack of good character. So just really important in terms of the licensing application as well, to be candid. And here's more about this case. So in this decision, the applicant had been a police officer and had a disciplinary history. There were questions on the licensing application that ask a number of questions about whether you had ever been, question 7, have you ever been suspended, disqualified, censured, or otherwise disciplined by a member of any professional organization? So when you look at that, the questions, he had not initially disclosed the disciplinary history. He subsequently did on an amended good character form. And when he did that, he reported he'd been disciplined 3 times for 8 findings of misconduct. The tribunal found that the conduct in deliberately misleading on the licensing application, that's what he had engaged in. And the good character application was dismissed. So he wasn't licensed. What about this? Am I safe now that I'm licensed and I've survived the good character requirement? Can I do what I want now? So that's right. No, you can't. Of course not, because you're joining a professional organization, a profession that, as I said in some of the earlier slides, that has been given the privilege of self-regulation, that we do so in the public interest, and that what we do is ensure that lawyers and paralegals meet the high standards of learning, competence, and professional conduct. So this question really looks at the professional conduct part of it. So we have rules that a code that sets out your obligations for being part of the profession, for being a lawyer or for being a paralegal. And as part of that, we have the rules of professional conduct. So that code, the rules of professional conduct, part of it talks about conduct unbecoming, and another talks about professional misconduct. So conduct unbecoming involving conduct in the lawyer's personal or private capacity, tending to bring discredit upon the legal profession, and professional misconduct being conduct in the lawyer's professional capacity, again, that tends to bring discredit upon the legal profession. So your personal or your private capacity are relevant, as is your professional capacity. So let's look a little bit more at these. So this is a decision from 2021, but it's really a decision that's had a 12-year history. So in 2010, the applicant applied to be licensed as a lawyer, but he was unsuccessful on the good character application. So he was not licensed in 2010. The applicant reapplied in 2012. This time, the good character application was successful, and the tribunal found that the applicant had used the time for therapy, counseling, personal growth. There was a forensic psychiatrist who testified that the conduct was likely to be repeated. So the applicant was licensed, became a licensee with the Law Society of Ontario. Fast forward 5 years later, so 5 years after being licensed and persuading the hearing panel that he was remorseful and that he had been rehabilitated, the licensee forged his client's name on 5 documents, falsely represented in jurats that his client swore or affirmed the evidence in those documents, served those documents on opposing counsel, and filed the documents with the Superior Court. And this went to a Law Society hearing. He was found to have committed professional misconduct. The hearing panel suspended his license for 3 months. He appealed that disposition, asking for a reprimand, and the appeal was dismissed. And that the appeal tribunal said it was important that the public and the professions and the licensee know that dishonest practices undermine confidence in the legal professions and in the administration of justice. So that was a case, good character, not successful, good character, met the standard for good character to be licensed, and then subsequent a finding of professional misconduct with a 3-month suspension. Here's a different case, and this is a case where there was professional misconduct, and this where permission was given for the licensee to surrender their license. So they lost the privilege to practice law, to be a lawyer. And here's some information on the slide about a lawyer for 30 years who had a stellar reputation, however, got involved in serious intentional professional misconduct, which involved misappropriation of about $85,000 of the client's trust funds, although that money was later returned. Mishandling of the client's retainer by transferring funds to themselves, to the lawyer, before completing the work. And similar to the last case, we have here fabricating evidence, swearing 3 false affidavits, and confirming false information in a letter to a judge. So extremely serious, intentional professional misconduct. And in that case, the tribunal looked at her conduct, where she admitted her conduct to the Law Society and to the client. She cooperated with the Law Society and was remorseful. And there was a consideration by the tribunal of whether or not she should be given permission to surrender her license or whether her license should be revoked. Because the presumptive penalty was revocation of the license. And she would be required to demonstrate exceptional circumstances in order to be given permission to surrender. And in looking at all the circumstances in that case, the Law Society Tribunal found that the exceptional circumstances had been met and she was given permission to surrender her license. Here's another one. This is professional misconduct. And in this case, there was a revocation of the license. So the licensee engaged in serious professional misconduct, repeatedly lying to a client about the work that he had done on the case and providing the client with elaborate forged documents, being court decisions and endorsements. Led the client to believe that the lawyer had obtained a damages award of $3 million. And once the deceptions to the client came to light, the licensee or the lawyer told the Law Society that this was an isolated occurrence, and the Law Society found out that that wasn't so. He was also charged criminally with attempting to obstruct justice, forgery, and fraud, and did not inform the Law Society of the charges as he was obliged to do. So the licensee sought permission to surrender the license, and it was held that the license was revoked. And the tribunal in this case looked at the planned, calculated, deliberate, elaborate, and extended conduct involved. They also looked at what that conduct did, not just for the client, but how it undermines the reputation and, as they say, the very bedrock of our justice system, and that the lawyer's misconduct not only profoundly breached the trust that his clients had placed in him, but also that the legal system and the public placed in him as a lawyer, and concluded that that conduct could only threaten the public's trust in all lawyers, and no exceptional circumstances existed to allow for the license to be suspended. And as a result, the license was revoked. And on the earlier slide, I talked not only about professional misconduct, but about conduct unbecoming. So conduct in your private or personal life that impacts negatively on the reputation of the legal professions. So in this case, we have conduct unbecoming, where the licensee was convicted of 5 counts of fraud and 6 counts of money laundering, sentenced to 2 years jail and 1 year probation, ordered to pay about $250,000 of restitution and a fine in lieu of forfeiture. And it was held by the tribunal, conduct unbecoming, and this licensee's license was revoked. So again, a withdrawal of the privilege to provide, in this case, this was a paralegal, and it was the provision of legal services. Okay, how about this one? Can a lawyer be disciplined for the content of their articling students' social media posts? Okay, so pretty close. This one is. Let's just see if anyone else wants to weigh in and tip the balance one way or the other. Okay, extremely close question. So the answers are 12 and 11, 12 yes and 11 uncertain and 1 no. Okay, so we have a few no now joining in. Okay, well, this is another case. The answer is yes. And here's the citation. So the lawyer had an articling student, and the articling student's communications raised serious concerns about her awareness of her ethical obligations. So civility, integrity, and confidentiality, and was posting on social media and where not only did it raise concerns about her awareness of her ethical obligations, but showed contempt and derision towards participants in the criminal justice system, and served to erode public confidence in the profession and the administration of justice. So the tribunal looked at the lawyer's duties to, number one, to be responsible for for supervision of the actions of the articling student, to provide direct supervision. And in this case, the tribunal looked at and the lawyer had done some things, but just not enough that behaved that. So the behavior was ongoing and the lawyer was trying to intervene. The behavior continued, and the tribunal looked at all of that and it just wasn't enough. So the lawyer was found to have committed professional misconduct for failing to adequately supervise and so the direct supervision and supervise the student under his direction. So really a lesson to all of us, the supervising lawyer, but also to those who are students and working for a firm or an individual. So we're going to move a little bit because I want to just talk about a few things at the Law Society, and then I'm going to open it up for questions. So I'm struggling and I'm struggling and not coping well. Does the Law Society have resources to help me? Again, pretty much overwhelming that the answer is yes, and that's correct. The Law Society does have resources to help. So when I was introduced, you heard that a focus for me in my 2-year term has really been the well-being of legal professionals. That's one of my focuses. And in part, that's because of the pandemic and how isolating it is, and how we're limited in our ability to have face-to-face interactions. You know, I'd far rather be seeing you in person than looking at a screen and not having that ability to interact. So I want you to know that the Law Society and Law Pro, so with Law Pro being the insurer of lawyers, they provide for licensees and students the ability to access the member assistance program. So the member assistance program is operated by Homewood Health, and we actually have an independent third-party intermediary between us because the member assistance program is confidential. They don't call the Law Society and say, did you know that this person is suffering from addictions or anxiety, or they don't do that. It's confidential. So when you call the member assistance program, you can get help. And they offer so much. They have counseling and coaching, online resources, and peer-to-peer supports. So some people don't want to speak to a counselor. So if that's where you're at, then use the online resources or the peer support. Speak to a lawyer or a paralegal who's experienced what you're experiencing, and reach out to them to share, to build understanding, to build strategies, just to work together to address what you're facing. And the areas that are covered by the member assistance program are really anything to do with wellness. So addictions, mental, physical health, work-life balance, career, family, elder care, finances, health and wellness, really anything to do with your wellness. So please reach out. And as I said, it's available to lawyers, paralegals, judges, students. So it's available to you now. So reach out. The contact information is at the bottom of the slide. And I just really encourage you to know that you don't have to go through this alone. That support is available for you. So please, please reach out. So how about this? Once I become a lawyer and start paying my fees, do I get anything for my fees? So again, a few people who are uncertain about this, but pretty overwhelmingly, yes, that you do get something for your fees. So these are some of the supports that the Law Society offers. We offer a coach and advisor network. So that's two different aspects. One aspect is coaching, where you would, and it's peer driven. So you would, if you wanted to develop a best practice or a skill, you would reach out to a coach. They'd meet with you for about an hour and a half, and then subsequent 30-minute sessions. I think there's about 5 of them. It's about a 3-month commitment, but it could cover anything from a skill development. So for me, I'm a litigator, a prosecutor, so I would be thinking of things like opening and closing statements, cross-examination, examination in chief, re-examination, or it could be just about your practice. I'm returning from leave. Or I want to build my practice, or how do I find more hours in the day? So lots of different topics. The second part of that is then the advisor piece, and the advisor piece is much more file specific. So I have a real estate file and I have a question on it, and you would be connected with a peer with experience in that area to assist you. We also have the practice management helpline, which is staffed by Law Society staff. If you have an ethical or a professional responsibility issue, you could call the practice management helpline for assistance. We have lots of online resources. You would start at your source and find lots of resources to help you. And those are on the Law Society website. I've already told you about the member assistance program. We also have a store, the Law Society store, where we host, we have a number of continuing professional development programs. So once you become licensed as a lawyer or a paralegal, you will have obligations if you're practicing to meet your obligations to continue to learn. We also fund Discrimination and Harassment Council. Discrimination and Harassment Council is a very important program that we fund. Again, it's independent and it's free to use. So you would, if you are experiencing or witness discrimination or harassment on human rights grounds by a lawyer, a paralegal, or a student member of the Law Society, you would reach out to Discrimination and Harassment Council, and they could provide you with information, with assistance to help you understand what your options are. Again, you're not alone. This program, Discrimination and Harassment Council, is staffed by 3 lawyers who are experts in their work. And this is open to any member of the public. So any lawyer, any paralegal, any student, any member of the public can use this program if they want to speak about witnessing or experiencing discrimination or harassment on human rights grounds by a lawyer, a paralegal, or a student member of the Law Society. Why should I stay connected to the Law Society? Because the Law Society wants you to succeed, because we have supports to ensure your career-long competence, all of the above. So the answer is all of the above. The Law Society wants you to be successful in your career. Remember, we're a public interest regulator. We want the members of the public served by lawyers and paralegals who meet the high standards of learning, competence, and professional conduct. So it's really important to us to support you throughout your career, to ensure career-long competence, to ensure career-long ethical behavior. We want you to succeed. We want you to be role models for the profession, to show to the public that their faith and trust in us as lawyers and paralegals is well placed. So here's some questions about how can you stay connected to the Law Society? Through social media, through lso.ca, that's our website, through attending virtual events. And to all of the above. So we host a number of virtual events through our Equity Legal Education series. So this is something different than our continuing professional development education courses that we offer. We also host approximately once a month. So last month in March, or I guess it's still this month, we did International Women's Day. In February, we did Black History Month. On Monday, we're doing International Francophonie Day. So these are virtual events. They're really important conversations that I encourage you to join in for. They're held virtually, they're free, they're accessible to anyone, including members of the public. And when you become a licensee, they're also CPD accredited for EDI professionalism. So the answer to this question is, of course, all of the above. Here's a way you can stay connected to us. So I am on Twitter at LSO Treasurer. The Law Society is also on Twitter. We have a corporate channel, and that's Law Society LSO. And the Law Society is on Facebook, Instagram, LinkedIn, and YouTube. So I encourage you to stay connected to the Law Society. It's important that you do so now. You'll find that I use my Twitter account for things that are of interest to the professions, to lawyers, to paralegals, and to the public. So it's time for questions. I'm going to stop sharing and ask that if you have any questions that you submit them through the question and answer tab. We have about 20 minutes.
Wonderful. Thank you, Treasurer. That was a wonderful presentation. And I really like the dynamic technology. It's given me some ideas for my own classroom. So that's wonderful. We have had a few questions come in. Maybe I'll use my moderator's privilege to ask you a first question. You talked about how lawyers can stay engaged with the Law Society and some of the ways to understand what the Law Society is doing through social media channels. For law students and their relationship with the Law Society, we know in the past there's been discussions about law students maybe having more formal roles and things like that, and debates about that and different approaches in different jurisdictions. But what are some of the ways you would say the Law Society now engages with law students, listens to their concerns, and if law students are interested in undertaking that type of engagement, what might be some opportunities?
So, yes, you're right. Last year we had motions brought asking for more involvement of law students in our processes, in our board processes. So we had two motions brought by the Law Student Society of Ontario. One of them was to have a bencher, and one of them was to have involvement at the Professional Development and Competence Committee. And so that matter came to Convocation, and Convocation ultimately decided not to support either of those. But I will tell you that even before those motions were brought, but even since, especially since, there's been a lot of engagement between the Law Society and students, especially through the pandemic, as we were transitioning and trying to figure out what was happening to law schools, exams, calls to the bar. There was a lot of connection between the Law Student Society of Ontario, between individual law students, between the universities, the law schools, because we really wanted input. So we have other processes. I've been going out to the law schools. I've done it 2 years in a row. Going out to the law schools and doing a presentation about all the supports that we have for that. Also looking at ways in which that they can be involved. I'm about to host a meeting at the end of the month with stakeholders, and the Law Students Society of Ontario will be involved. I meet on a fairly regular basis with Ocean Enbar, who's the president of the Law Students Society of Ontario. He's involved in different tables that I sit at as well. They've attended the professional development and competence committee. So we're bringing them into our processes so that even though formally they weren't admitted as being a bencher or being at the PD&C table, that there are other ways in which we're engaging them and really working on that. To continue to build our interaction, including now well, I guess it closed on the 15th, but we did have a question about minimum compensation for students. And, you know, I spoke to him about that as well. So lots that there is interaction going on and we value it. And it's really important for the work that we're engaged in.
Thank you. And yeah, and we certainly appreciate you coming to the law school here and also highlighting those supports. I want to underscore your comments about the members assistance program. I know that a lot of law students don't know that's available, and I just encourage people to check that out. It's something the Law Society is already kind of doing to provide assistance. I do see some questions in the Q&A, and I encourage people to continue to submit questions. Another type of issue in terms of connecting with the Law Society, if a student or a lawyer has an ethical issue they want to discuss with someone at the Law Society, what's the best way to contact the Law Society for help? What might be various avenues?
So for the lawyer would have to be, you would call the practice management helpline for the lawyer. That's what I referred to at the end on one of those slides. And what we have, Amy, is we have a document, like a 1 or 2 pager that's available in English and in French that we'll send to you for you to distribute to all the law students that you want to and who's ever's on the call, just about the supports and resources that are available. But the starting point for that would be the practice management helpline. As I said, that's staffed by Law Society staff, and about questions about professional responsibility. So that's where the starting point would be.
Sure. And maybe someone, and I don't know what this question is directed at, perhaps if a student was in an employment situation and was having challenges, people they're working with, I believe the Discrimination Harassment Council may be open to them. And certainly, there's the ability for anybody to file a complaint as well. I think would be also.
Yeah, for sure. Yes.
Yeah.
And as I just can't reiterate enough, the Discrimination and Harassment Council, I wrote a blog about it because I spent 26 years dealing with victims of crime, and I know how important information is. To me, information is power. And so I also know how hard it is to tell about what's happening to you if you're being mistreated or discriminated or harassed, that it can be hard, especially in your professional capacity, to say what's happening. So I wrote a blog about it. It was in August, in the Gazette in August. So if you Google Law Society Gazette, Discrimination and Harassment Council, it'll pull up the article that I wrote, because to me, it was really important that people understand what will happen, what their options are, and to know that they're not alone and that they can reach out. And again, that's the free resource that's available to any member of the public.
Yeah. Yeah, and really amazing people that staff it. And one thing I really appreciate is the reporting that comes out of that office, because it does give us a picture, like you said, of some of the issues that are happening. I see another question more related to current events. Many of us saw in the news some issues about the material for the bar exam potentially being compromised. And that led to the canceling of the bar exam in March. So the question asks, is the Law Society considering alternative approaches to the bar exam? So we know other provinces adopt different approaches to that kind of aspect of licensing. Is that something on the table? Do you think it might be on the table in the future?
Well, I would say immediately that it's not on the table now today for licensing candidates that are going through the process right now. And that we're reoffering the exams. We know how important it is to proceed with licensure. We've known that all the way through the pandemic. That's been a priority for us. So in the short run, no. Is that something that we'll look at? We're always looking at what the sort of the policy issues and whether the way we're doing things are right in terms of licensing or competence or professional responsibility. So I do know that there have been some students who've asked us to look at that, and that's something that, I mean, I can't commit the treasurer going forward, and my term's done at the end of June, but that's certainly something that we know at the Law Society. Priya Bhatia, who's the head of professional development and competence, the executive director, she's aware of it as well. So these are things that going forward we can look into, but to say that in the short term that's something that's going to happen now, it's to me that's not realistic. What we have to do now is to focus on getting our exams back up, and it's a longer term policy decision. About whether in the future we should be changing how we're licensing candidates.
Okay, thank you. You mentioned, and here I'll interject a question of my own because some people may not be aware. You mentioned the issue of your term coming up as treasurer and a new treasurer will be in place. Can you just discuss how the Law Society chooses a treasurer and how that happens? I know I've talked to my class certainly about benchers and things like that, but those processes are a bit distinct, aren't they?
Yes, so we have a board of 20 lawyers, elected lawyers from inside Toronto, 20 lawyers elected from outside of Toronto, 5 paralegals. So those are all the elected lawyers and paralegals. And we have 8 lay benchers who are not lawyers or paralegals who are appointed by the Attorney General. That makes up our board. That board elects the head of the board, and that's me, that's the treasurer. So those elections, they're to happen every year, but as I was introduced, I was acclaimed for my second term. So that election will take place in mid-June. The nominations will close, I'm going to say the first, or I think it's the second week in May. And sitting benchers can run to be the treasurer. And then there's an election. And so we moved it, we changed it a little bit this year, because what was happening was the day that you become elected as the treasurer, you also take over the board meeting and run the board meeting.
Oh, wow. Okay.
I can tell you that's not an optimal way to make it work. I had full board meeting that day. So what we've done is we've actually moved it up ahead of time. So the election will be a week earlier, and then there'll be a week-long transition period for the incoming treasurer and me as the outgoing treasurer to work together on the issues and upcoming convocation, and convocation is our board meeting. So I think it's just a much better way, having lived through it, a much better way of governance and of transitioning the leadership of the professions as well.
Right. Well, it always strikes me as such a short time, and I think that's probably characterized of the whole 1 or 2 year term, and so we'll have that treasurer, the benchers will elect the treasurer this summer, and then my understanding is, if I got my timing right, the upcoming spring in 2023 there'll be a bencher election as well.
Yes,
right?
That's right. And this is my call to everybody who's here to vote in that election. The turnout in the bencher elections has not been good in the past number of years, and it's a really important opportunity to have a say in the regulation of the profession. So for lawyers and for paralegals to vote, for the people who are at the table and who are making decisions. So really, really important. When you have the opportunity, take advantage of it. Because you might not like some of the decisions. You might not like those decisions that we made about students, or that convocation made. I actually don't vote. I'm the chair of the board, so I'm not involved in those debates or in voting. But you might not like those decisions. Well, if you don't like those decisions, then change who's at the table. And that means exercising your right to vote when you have the opportunity.
Yeah, I mean, it's I try to, convey the message, part of being a regulating profession, and we can look at these rules and decide, we may want to do things differently. A few questions related to some of what you talked at the beginning of your presentation about good character, and maybe I'll just couple two together. And I know it's never good to ask compound questions, but I may. You're taking notes, so that's good. So one person wanted to know where you have a lawyer who has previous criminal convictions, does the public have access to that information? And then the second question, in the good character process, you talked about omissions, can constitute misrepresentations. This person wanted to know if an inadvertent omission would be deemed to be something that would be a disqualifying misrepresentation.
Okay, so let's just go to the first one. So interesting question about access to previous convictions. So I'm going to talk with my Crown hat on, because for me, like as a Crown, the criminal courts they're public, right? So unless there's a ban on the publication of the name, that information is public. It might be hard to find, right? Like on the court website, or unless there's a decision reported on Canley or whatever. So those things might be hard to find, but a couple things. So the Law Society decisions are on Canley. So I refer to all those cases today. They're all on Canley. So they are all public. We also have a Law Society directory. And so it's a lawyer and paralegal directory. It's free. Once you become licensed, you'll be on there. And if you go on it, there's a part that says regulatory history. And if it says yes, then you can click on that and you can access information. But we are also looking at that. We're also looking at that directory and whether it should contain more information and easier information to find. So that's something that's on our agenda, on our radar about that. Because I think that really raises a good point. We're regulating in the public interest, and how does the public know about these things? Like, is it realistic to think that the public's going to go on Canley and search the Law Society Tribunal hearing division and appeal division cases to find out whether they should be hiring a lawyer?
Yeah.
So I think that's a really important point. The other one about omissions is, when I was talking to you about what was found to be deliberate misrepresentations. So I'm not trying to scare you to say, oh, if you make an inadvertent admission, you're never going to get licensed. I don't say that at all. I say, I can't specifically say yes or no, but what I can tell you is if you make an inadvertent admission or omission and you figure it out and correct it, or it's drawn to your attention and you figure out and correct it, I think that's something really important. And what I was talking about in that case that I referred to was where the person was found to have deliberately not told the information. And I gave you two examples, one about the conduct in law school, and the other one was the police officer who had 8 findings of misconduct. Like that's hard to understand that could be an oversight.
Right.
So,
well, and one thing, oftentimes when I talk about the good character process with students, part of it is we look at some of the policy critiques, but also to note that, and I don't have the statistics with me, if you do end up checking yes and disclosing something to one of those questions, it's only a very few number of those things that actually go to a full good character hearing. Oftentimes those things are dealt with internally or ask for a bit more information. So the questionnaire is fairly extensive, but you're not necessarily caught in a whole regulatory process just because you're disclosing things that you need to disclose. And so, right. I try to reduce anxiety in that way as well. Though people have written, I think, quite well about how even sometimes those internal, investigations can be quite stressful. So I don't want to discount that, but
right.
Yeah. All right. Well, Treasurer, my clock just struck 12:50. So if you want to leave any last thoughts with us, I welcome that. I see that there was even more questions coming in, and so I regret that we're not able to get to all of them. But we really very much appreciate your time today, an informative, engaging presentation, and a great way to launch this Conway Professionalism Speaker Series. So I will give you my virtual or physical clap. Thank you so much. That was wonderful. And yeah, I'll turn it to you and for any last minute comments.
So thanks everybody for joining today. And I'll say to all the law students out there that I'm very much looking forward to you joining the Law Society. I'd say the practice of law for me has been a wonderful profession. I'm so honored to be part of it and just really happy that you're going to be joining it. And I just the fact that you're here today listening to this professionalism series shows your level of interest and dedication to the profession that you're going to become a part of. I encourage you to attend the rest of them. The words that Tom gave at the outset are just so motivating in terms of, you know, what's important in our profession, and really, really important that you understand professional ethics and responsibilities. And as he said, that they be at the forefront of who you are as a lawyer. Thank you.
Thank you very much. Everyone, please have a good day. Take care.